If you have been sitting around waiting for your green card, monitoring the Visa Bulletin each and every month, constantly reloading the Department of State's webpage, tallying up the days, wishing for some positive development, then this particular video was crafted specifically for you. Because at this moment in 2026, there are genuine shifts occurring within the priority date framework that could influence when your green card actually arrives. And if you fail to comprehend what these shifts signify, you could lose a vital opportunity that may not present itself again for months or possibly years. So remain right here, because by the conclusion of this video, you will understand precisely what is unfolding in the Visa Bulletin during this fiscal year, what it indicates for your particular category, and the definite actions you can implement right now to guarantee you do not get left behind. Welcome to US Updates Hub. For years, this channel has been assisting individuals exactly like you in navigating one of the most intricate systems across the entire United States immigration process, the priority date framework. This is not merely about figures displayed on a government webpage. This concerns your family, your future, and your position in the queue. So let us dissect everything together thoughtfully, plainly, and with as much actionable guidance as can be provided. First, let us ensure everybody shares the same understanding about what a priority date truly represents. When you or your employer submits an immigrant visa petition to USCIS, that is United States Citizenship and Immigration Services, you are assigned a priority date. Consider it your timestamp, your reservation in the queue. It is typically the date when the petition was correctly submitted, or in employment-based situations where a labor certification is necessary, it is the date that the Department of Labor received the labor certification application for processing. This date is permanent. It remains with you, and your responsibility from that moment onward is to wait until the cutoff date in the monthly Visa Bulletin reaches your priority date. When that occurs, your priority date is considered to be current, and that is when you can proceed with the concluding phase of your green card process. Now, here is where matters become critical, because the Visa Bulletin is not simply one figure per category. There are actually two charts that are significant. The first is known as the Final Action Dates chart, occasionally described as Chart A. This is the date your priority date needs to proceed in order for a visa to actually be granted to you, or for your adjustment of status application to gain approval. The second chart is termed the dates for filing, occasionally labeled Chart B. This is an earlier date that, when sanctioned by USCIS, permits you to lodge your I-485 adjustment of status application even before a visa number is technically accessible for final approval. The difference between these two charts is tremendously consequential, and the circumstances in 2026 are rendering it even more critical. Every month, USCIS declares which chart applicants may utilize, and that declaration can transform the entire landscape for tens of thousands of individuals virtually overnight. So, what is actually transpiring right now as of April 2026? Let us examine it category by category, because the picture is authentically mixed. There is both encouraging news and some warning indicators worth recognizing. Let us begin with the employment-based categories, because there has been a substantial shift that caught many applicants off guard. Throughout much of the initial months of fiscal year 2026, USCIS had been sanctioning the more favorable dates for filing chart for employment-based categories. That permitted a broad window for applicants to lodge their I-485 applications, even if their priority dates had not yet become current on the final action chart. April 2026 was a groundbreaking month for this purpose. EB2 worldwide achieved current status, meaning applicants in most countries outside of India and China could file without limitation. EB3 experienced meaningful forward progression as well. It was by many evaluations an uncommonly generous month in the Visa Bulletin. But with the publication of the May 2026 Visa Bulletin on April 2, 2026, the Department of State declared a pivotal transition. As of May, all employment-based applicants must now utilize the more restrictive final action dates chart, Chart A, instead of the dates for filing chart. USCIS validated this on its official adjustment of status filing charts page. What this signifies in straightforward terms is that the broad filing window that existed in April has effectively shut for employment-based applicants. If you were getting ready to file based on the more generous dates for filing chart, and you have not yet turned in your I-485, you need to speak with a qualified immigration attorney without delay, because the window is no longer accessible in the same manner. Now, why does this occur? Here's the reasoning behind the scenes, and it is essential to grasp this so you are not blindsided in the future. When dates progress substantially in the Visa Bulletin as they did in April, it produces a wave of new applications to USCIS. The Department of State needs to observe how many I-485 submissions actually enter the system before they determine whether to keep progressing, remain steady, or in some instances, retrogress the dates. May is what analysts frequently describe as an observation period. The system essentially halts after a significant advancement to evaluate demand. This is not an indication of failure or reversal. It is an inherent characteristic of how the numerical management process operates under the Immigration and Nationality Act. For applicants from India and China in the employment-based categories, the outlook continues to be challenging as it has been for numerous years. EB2 India, after progressing by roughly 10 months in April to reach July 15, 2014, has remained at that date in May without further advancement. EB3 India likewise stays stalled at November 15, 2013. EB2 China and EB3 China are stalled at September 1, 2021 and June 15, 2021 respectively. These backlogs persist because of a statutory per-country ceiling fixed at 7% of the total annual employment-based visa numbers, a ceiling rooted in Section 202 of the Immigration and Nationality Act. With India and China representing such a disproportionately large portion of petitions, the per-country cap generates waiting periods that can extend for well beyond a decade. It is one of the most debated structural obstacles in the legal immigration system, and it remains unmodified by legislation as of this recording. There is also a particular caution in the May 2026 bulletin that EB5 unreserved India may encounter retrogression or be rendered unavailable later in fiscal year 2026. The Department of State explicitly referenced sufficient demand and heightened number usage. If you possess an EB5 unreserved India case with a priority date close to the current cutoff, the recommendation from immigration analysts is unambiguous. Contact your attorney and contemplate filing without hesitation. Now let us discuss family-sponsored categories, because this is where the most encouraging progression in May 2026 is focused. Family-based applicants continue to gain from USCIS's sanctioning of the dates for filing chart, meaning they can still employ the more favorable Chart B for lodging I-485 applications in May 2026. This is noteworthy and constitutes a genuine opportunity for qualifying applicants. The highlight this month is in the F2A category, that is spouses and unmarried children under 21 of lawful permanent residence. This category leaped roughly 6 complete months across every country on the planet. The F2A final action date has progressed substantially, and on the dates for filing chart, F2A stays current for all countries. If you are a green card holder with an outstanding family petition for your spouse or young children, this merits your immediate attention. Examine USCIS's official adjustment of status filing charts page and the Department of State's Visa Bulletin to determine if your circumstances have shifted. F1, which encompasses unmarried sons and daughters aged 21 and older of U.S. citizens, also registered solid forward progression in May between 4 and 6 months for most countries. F3, which encompasses married sons and daughters of U.S. citizens, and F4, which encompasses brothers and sisters of U.S. citizens, also recorded improvements this month, with the Philippines category for both witnessing particularly remarkable gains. No family-sponsored category retrogressed in May 2026. That is authentically positive news and mirrors what analysts characterize as surplus capacity in the family allocation for this fiscal year. So what does all of this translate to in practical terms? What should you genuinely do with this information? The first thing, and I cannot emphasize this forcefully enough, is to identify your priority date. Retrieve your approval notice for your I-130 or your I-140, whichever pertains to you, and verify the date on that document. If you are uncertain where to locate it, consult with the attorney or accredited representative who assisted you in filing or sign into your USCIS online account where petitions are commonly tracked. Your priority date is the cornerstone of everything. The second step is to visit the Department of State's official Visa Bulletin accessible at travel.state.gov. Search for your category and your country of birth, not your country of citizenship, but your country of birth. Identify the relevant cutoff date. If your priority date is earlier than the cutoff date on the chart, your date is current, or you are at minimum within the window for filing depending on which chart pertains to you. If your date is later than the cutoff, you are still in the queue. The third step is to review USCIS's Adjustment of Status Filing Charts page at uscis.gov. This is where USCIS declares each month whether applicants should reference Chart A or Chart B. As of May 2026, family-based applicants utilize the dates for filing chart and employment-based applicants utilize the final action dates chart, but this can shift month to month. So you want to verify it every single month. The fourth step is to assemble your documents ahead of time. Whether you are waiting for your priority date to become current or it already has, the period between now and your filing date is not idle time. Employ it to collect the documents you will require, items like your passport, birth certificates, police clearance certificates, medical examination results, affidavit of support, evidence of employment or income, and any previous immigration records. Document assembly can consume weeks or even months in certain situations, and having everything prepared means you can move swiftly when your window presents itself. The fifth step is to engage with a qualified immigration attorney or an accredited representative if you have not already done so. Let me be absolutely explicit here. Everything shared with you on this channel is educational and informational. Immigration law is deeply individualized. Your specific situation, your category, your country of birth, your petition type, your employment situation, your family circumstances. All of these elements carry enormous weight. What pertains to one person may not pertain to another. A professional can examine your complete picture and assist you in making informed choices customized to you. Let me provide you a real-world example to help illustrate this concept. Picture someone named Priya, a software engineer from India who has been employed in the United States on an H-1B visa. Her employer submitted an I-140 petition on her behalf under the EB2 category back in 2016, assigning her a priority date somewhere in that year. Examining the May 2026 Visa Bulletin, her category EB2 India carries a final action date of July 15, 2014. Her priority date of 2016 has not yet become current. She cannot submit her I-485 or obtain a visa number at this moment, but she can keep maintaining her status, monitoring the bulletin monthly, and assembling her documents. If progression persists and her date eventually becomes current, she must be prepared to move swiftly because the window can shut as abruptly as it appears. Now picture someone named Maria, a green card holder whose U.S. citizen sister submitted an I-130 petition for her years ago under the F4 category. Maria was born in the Philippines. The May 2026 bulletin displayed meaningful forward progression for F4 Philippines. Maria needs to navigate to the official Visa Bulletin, locate the F4 row, and examine the column for the Philippines. If her priority date is earlier than the cutoff, she may now be positioned to file using the dates for filing chart. Since USCIS is sanctioning that chart for family categories in May, Maria should contact her attorney immediately because this variety of opening does not always persist. One of the most valuable practices you can develop as someone traversing this process is to review the Visa Bulletin every single month. It is published by the Department of State typically around the middle of the month preceding the month it addresses. So the May Bulletin was published on April 2nd, 2026. The June Bulletin will arrive in May. You want to be examining it as soon as it is published because USCIS then typically declares within a week or so which chart you may utilize. Between those two declarations, you have your window to comprehend where things stand and implement any required steps. I also want to discuss the wider context of fiscal year 2026. The fiscal year for immigration purposes extends from October 1st, 2025 through September 30th, 2026. As we progress into the second half of this fiscal year, May through September, the Department of State is actively overseeing how many visa numbers have already been consumed and how many remain. This is why you can observe substantial forward progressions in some months and then a halt or even retrogression in others. The objective is to consume all the visa numbers Congress has sanctioned without surpassing them. And that balancing exercise plays out in the Visa Bulletin month by month. For fiscal year 2026, the statutory ceiling for family-sponsored preference immigrants is 226,000, and the worldwide threshold for employment-based preference immigrants is at least 140,000, as established under the Immigration and Nationality Act. What should you monitor in the upcoming months? Immigration analysts and legal practitioners indicate that employment-based progression may restart after the halt in May, particularly in EB3 categories and for applicants from countries other than India and China. The State Department needs to examine how many submissions arrived from April's broad window before it resolves to progress again. If that wave does not materialize as intensely as anticipated, there may be capacity to advance dates forward again in June, July, or August. For family categories, F2A may continue to progress given that the final action date has been approaching recent years swiftly. And naturally, the India EB5 unreserved caution from the May Bulletin is an active situation that could shift at any moment in the remaining months of fiscal year 2026. What you should not do is panic, surrender, or make impulsive decisions without consulting a professional. Retrogression, when dates shift backward, does occur, and it is unsettling, especially if you have been waiting for years, but it is also a foreseeable characteristic of a numerical framework that is administered month to month. The path forward is to remain informed, remain organized, remain connected to your legal support network, and take action when your window presents itself. Before I conclude today, I want to briefly highlight something that frequently gets disregarded. Your country of birth for Visa Bulletin purposes is not necessarily where you hold citizenship or where you carry a passport. It is the country where you were born. And if you were born in a high-demand country like India or China, that dictates which column of the Visa Bulletin you reference. In certain circumstances, a person may be able to claim chargeability through a spouse born in a different country, a concept recognized as cross-chargeability, which can occasionally unlock faster timelines. Once again, this is precisely the variety of nuanced strategy that an immigration attorney can assist you in assessing for your particular case. As always, I want to emphasize that everything shared on US Updates Hub is for informational purposes only and does not represent legal advice. Immigration policy can and does shift, sometimes rapidly and without substantial warning. The information in this video reflects the Visa Bulletin and USCIS guidance as of April 15, 2026. Please confirm all details through official sources. That means USCIS at uscis.gov, the Department of State Visa Bulletin at travel.state.gov. And if you are uncertain, please engage with a qualified immigration attorney licensed in the United States. If this video has assisted you in better understanding where matters stand with priority dates in the Visa Bulletin in 2026, I would truly appreciate it if you would take a second to press that like button. It may seem minor, but it authentically helps this channel connect with more people who are searching for precisely this variety of clear, truthful, practical immigration guidance. We address the Visa Bulletin every single month along with breaking developments from USCIS, DHS, and the Department of State, policy modifications, and practical guidance that assist you in understanding your rights and your options. We are here every step of the journey. Review the video description below for links to official resources, including the Department of State Visa Bulletin and the USCIS Adjustment of Status Filing Charts page. Forward this video to someone you know who is on this path because dependable information transforms lives. Look after yourselves, keep your documents organized, keep reviewing that bulletin, and we will see you in the following one.